This is Bloomberg Law with June Grasso from Bloomberg Radio.
Los Angeles District Attorney George Gascon is recommending that Eric and Lyle Menendez be resentenced for the 1989 murders of their parents.
I have to tell you that after a very careful review of all the arguments that were made for people on both sides of this equation, I came to a place where I believe that under the law, resentencing is appropriate.
He's recommending a sentence of life with the possibility of parole instead of their current life sentences without parole. The brothers will be eligible for parole immediately if a judge and the parole board agree. Joining me is Palm Beach County State Attorney Dave Aronberg. Dave, tell us why the district attorney said he's going to recommend having the Menendez brothers resentenced.
Well, first, you have a reform-minded district attorney there who has done other resentencing. He's been criticized for his approach to the criminal justice system. He has an election in 2 weeks against a challenger who's running on a tough-on-crime platform. But he is true to who he is. This district attorney is someone who believes in rehabilitation, and he made a big point of saying that the Menendez brothers were model prisoners, even though they got life in prison and had nothing to live for, that they were model prisoners. But he also stressed that there was new evidence that showed that the brothers were subjected to sex abuse at the hands of the father. So he is not supporting the downfiling of the charge to manslaughter. He's saying it should be resentenced as murder, but that since the two brothers committed this horrible crime while they were under the age of 26, they were 21 and 18 at the time, that they would be eligible for parole. And so he's recommending that they be resentenced to murder 50 to 100 years with parole, essentially to be resentenced with parole as opposed to life without parole. And then the parole would be eligible immediately. So conceivably, if a judge agrees, and the judge still must agree, the Menendez brothers would be resentenced, go before the parole board, and possibly released.
So did it seem as if he was backing into it, like that he set it up so that they could be released immediately if a judge agrees?
You know, it's interesting. I think he did it this way so that he was involved in it, but it's not his decision to release it. Ultimately, it was going to be the judge's decision, but he added an additional layer on top of that. Not only will it be the judge's decision, it'll also be the parole board's decision. So for those who say, hey, you released the Menendez brothers, he can rightfully say that, no, I just recommended something, but it was the judge and then this parole board that made that decision.
So he talked about the two trials of the Menendez brothers. Explain what happened at the two trials and the sexual abuse allegations.
The two trials took place, and the first one ended in a mistrial, a hung jury, and then there was a second trial, and the second trial, the judge did not allow the claim of sexual abuse to come in for the defense. The defense wanted to go into the issue of sexual abuse. There wasn't as much evidence of it back then, plus it was a different time, and these issues were not as prevalent in these types of cases. And so the judge said, no, you can't bring it up. You can't bring it in, and the brothers were found guilty. You remember during the first trial there was an outcry because people thought these brothers were just vicious killers who were doing it because they didn't want to get written out of their father's will, and then once they slaughtered their parents who were eating ice cream in front of the TV with their backs turned to these brothers who premeditated all this, who planned this, that they were dressed at the trial in these soft sweaters that made them look like Mr. Rogers, and there was a hung jury. But then in the second trial, with the new instruction from the judge that they could not use the abuse excuse, then the jury found them guilty. They were sentenced to life in prison without parole, and here we are today.
How much of this do you think can be attributed to the Me Too movement and the different way we have of looking and accepting allegations of child abuse and sexual abuse?
There's some of that. It's a different time. But also social media. You had celebrities weigh in on the Menendez brothers. They caught on the social media circuit where you had people saying, hey, these brothers were abused, especially when the new evidence came out, and they're so interesting and they should be talked about. And then the pressure increased, and family members even got involved on their side. And eventually, it came to this. And so, yes, when you add that we're living in a different time, and you had more understanding of sexual abuse, and you have the social media aspect in it all, and celebrities, it culminated into the DA recommending that they be resentenced. Normally, it's the DA that resists it. Remember, this was a motion filed by the defense lawyers a while ago in front of the judge, and it was pending in front of the judge. The DA did not have to give this recommendation, but he did. That's what's so interesting about this, is that normally the DA is the one who says, no, let's keep him behind bars. Now, my issue as a sitting prosecutor is not with the DA's recommendation when it comes to the murder of the father, Jose. He was apparently, according to the evidence that has come out, he was accused of sexual abuse, not just against the sons, but against one of the members of Menudo, who came out and said that this guy sexually abused him. So I understand how the prosecutor here could try to resentence the brothers because this perhaps is more of a manslaughter case than a murder case because of the abuse allegations that now have credence. But what about the mother? There's no credible allegation that the mother was sexually abusing the children, and yet they slaughtered the mother. Not only did they murder the mother, Lyle Menendez shot the mother, and the mother did not die, and she was crawling away, desperately trying to save her life when he ran outside to reload and then ran back into the house to finish off her mother, and it did so in such a bloody, calculated, brutal way that law enforcement thought it was a mob hit. It was the mafia that did this, and the boys lied about it and lied repeatedly about what happened, and then went on a shopping spree, and then traveled and got tennis lessons and threw parties and lived a high life, living off their family's money until they're eventually caught.
The prosecutor mentioned that after Netflix began streaming the true crime drama Monsters, the Lyle and Eric Menendez story, his office was inundated with calls from the public, and that's why he says he decided to move up this decision. How much of this decision do you think is because so many people watched those documentaries and saw a different side of this, and it's been the subject of debate once again?
Well, that's the culture we're in today. You know, we're so divided on everything, it seems like, and we're divided on this as well. And there are people who are years removed from the situation who now look at the brothers as victims themselves, when a lot of us who were around when this happened thought of them as spoiled, entitled, brutal killers who planned this murder, lied about it, and then joyfully spent the money that was their parents on themselves. I guess people grieve in different ways, but in this case, it was not a good look for them. And years have passed, and the one thing that, a couple things that have come up in their favor, that first, they have been model prisoners. They have been. I don't think anyone disagrees with that. And there is now new evidence that shows that it looks like Jose, the father, did engage in sexual abuse against the brothers. Now, is that enough to release them? I don't think so, but I'm not the DA there.
They have served 35 years, though.
Well, for murder, you can get life, and you should. First-degree premeditated murder gets you life or the death penalty. That's what they were convicted for, first-degree premeditated murder, and not just murder, double murder. So although I do understand reducing the sentence for the father's murder, because that could be more of a manslaughter case, I understand getting parole for that, I still would not have supported that for the mother, because the way the mother was killed was unnecessary, was particularly brutal. And it was clear to me that the reason why they killed the mother was to eliminate the witnesses so they could claim that they were innocent, they had nothing to do with this, and they can go on their spending spree. But they were convicted of both murders, and now it looks like they're going to get out.
Well, you feel that way, and apparently a lot of people in the prosecutor's office feel that way. Do you think that the judge or parole board will say, no, we're not going to do this?
I think when the prosecutor's office recommends a resentencing, then the judge and the parole board would probably go along. I think they would expect the prosecutor's office to resist it, and when they're in favor of it, I do think that the chances are likely they will go free now. And then I guess they could try to monetize their experience and sell books and movies and reality show. And so that could happen. But they'll never be able to escape what they've done. And the DA did say that. He's not condoning it, not excusing it. It was a brutal murder. And even if you're the victim of abuse, you should report it to authorities. You don't get to take the law in your own hands. But I do think that they're getting out, if they do get out, too early for this double murder. Again, maybe it'd be justified for the murder of the father to get out after 35 years, but the murder of the mother, I think the life sentence was appropriate.
Do you think that there'll be some questioning of this decision because of the timing so close to a close election for the district attorney?
Yeah, there are going to be questions about that this took place 2 weeks before the election, but and the DA is on the ballot. But the DA is within his rights to do it now when this motion has been pending for a while, and he perhaps wants it to be done now before the November election takes up all the oxygen in the room, and before the Dodgers are in the World Series, before the first game, because that will take up all the oxygen in the room as well in Southern California. So perhaps he thought today was the best day to make his announcement.
We'll see what happens with the judge and the parole board. Thanks so much, Dave. That's Palm Beach County State Attorney Dave Aronberg. I'm June Grasso, and you're listening to Bloomberg. Donald Trump is ramping up calls to carry out mass deportations of immigrants if he returns to the White House by dusting off part of the Alien and Sedition Acts of 1798.
I will invoke the Alien Enemies Act of 1798. Think of that. 1798. This was put there. 1798. That's a long time ago, right? To target and dismantle every migrant criminal network operating on American soil.
The law allows the U.S. government to detain and remove non-citizens of hostile nations during wartime. It's the same law which was infamously used to justify the confinement of Japanese Americans and others during World War II. Joining me is immigration law expert Leon Fresco, a partner at Holland Knight. Leon, Trump is promising to carry out mass deportations by using this 226-year-old law. Is what he's suggesting legal, using that act?
Well, here's what it's going to come down to, like everything else. It's going to come down to a matter of statutory interpretation, because the Alien Enemies Act of 1798 actually has a provision in it that says that the quote-unquote invasion that's happening as a result of the Alien Enemies Act has to be sanctioned by a country, meaning there has to be a country that's actually involved in sending these people invading into the United States, as opposed to people taking matters into their own hands and crossing into the United States. So what the Trump administration is going to say is, we are being invaded, especially by gang members of certain countries, and the one he's most concerned with is Venezuela. And what he's going to say is that these gangs from Venezuela are actually being sent to the United States in, quote-unquote, some sort of act of hostilities here, as a matter of them trying to clear out their gang members and cause instability in the United States and trying to add gang members into the United States. So that's what's going to be up to the court to figure out. And so I very much doubt that this statute will be applied to basically permit this kind of no due process deportation where you don't pass go, you don't collect $200, you just can immediately be rounded up and sent out. But I do expect the Trump administration to try, and I do expect this case to get to the Supreme Court, and then it'll just be a very interesting question of what will the Supreme Court say? Are there 5 votes on the Supreme Court to say that the people who are coming here, who are gang members, are in some way being sent here? And so I do think if the Trump administration gets into power, it will actually have to try to build a record of this before it enters this order. And it will actually have to say, here's all the evidence we have that the people from Venezuela who are the gang members, or let's say from some other country who are the gang members, are actually being sent here by a foreign nation.
And an operation like this would be incredibly expensive.
Well, that's another story in terms of, yes, how much would it cost to do it? Because at the end of the day, you have two problems. One, you have the due process problem of can you actually do the deportation legally? But second, you have the problem of, okay, now what? Does Venezuela actually let the planes land of the people we're trying to deport? And if they don't let the planes land, then what? Then what are you doing with this? Are you going to try to deport them to some other country? Will you have to pay for some other country to let you do this? Will you have to pay for Venezuela to let you do this? That's a big problem logistically. That's number one. But then the second issue is, okay, where are these people waiting while you're doing this? Are they waiting in detention? Then the detention will cost somewhere, let's say, the bare minimum will be $60, $70 a day per person detaining them. And then there are the costs to the economy of what happens when you take all of these people out of the economy where they're currently working. So you're losing all of that revenue. And on the other side, now you're paying government revenue to detain them. So, yes, it ends up being very costly. What the Trump administration would say is, well, but we're going to get that all back with higher wages to the remaining people who remain in the workforce and advanced economic opportunity for the remaining people that remain in the workforce without jobs or that have jobs, but now their jobs will pay them more because there's fewer workers in the pipeline. But we will have to wait and see. I mean, the typical economic studies that have been done in this regard say that when you take workers out of the economy, especially workers like this who don't qualify for government benefits, because all the main government benefits, food stamps, welfare, and Medicaid and Medicare and all of that, all require legal status to get it. And so all these people that you'd be taking out of the economy who are working and taxes are being paid either through the rent that they pay or sometimes they pay actual income tax and withholding is happening. The Congressional Budget Office, when it does these studies, always says that when you take people out of that scenario, you cause massive government deficits.
I just want to note that the highest number of removals under Donald Trump's watch occurred in 2019, with more than 347,000 non-citizens removed. Compare that to former President Barack Obama, who oversaw the removal of more than 430,000 non-citizens in 2013. Now let's turn to some election lawsuits where immigration is now coming up. A series of Republican states, including Texas and Florida, are suing the Department of Homeland Security. They claim they're moving to purge their voter rolls and they need information about immigration status. For example, Texas wants the federal government to turn over the immigration status of 450,000 potential voters in the state. What's going on here, Leon?
So what happens is there's a database called the SAVE database, the Systematic and Alien Verification for Entitlements Program. And what basically happens there is when a state has to do something that depends on the person's lawful status. So, for instance, under the Real ID Act, if a state wants to comply with Real ID, it has to check the immigration status of someone so that it's not giving a license to someone who's undocumented. And so what the federal government does is it's given the states access to this database called the SAVE database, which allows you then to check if the person actually has lawful status vis-a-vis the federal government. So now what the states are saying is, well, let us check this SAVE database to see if the person can vote so that we can take them off of our voter rolls. And what the federal government is saying is, look, this is a database that tells you about a person's lawful status. But what happens when people actually naturalize is sometimes people change their name. They didn't want to change it during the immigration process because they didn't want to create a problem. But now the naturalization process gives them the opportunity. A lot of times that happens because somebody will marry a U.S. citizen. They'll go through the current process of getting a green card with the name they already had pre-marriage. But, you know, once they get to the citizenship part, they want to finally take the name of the spouse. And so all of those people won't show up in the SAVE database as having naturalized because the name will be different. And what they don't want is a situation where Texas or some other state then wipes that person off the roll because there was a misunderstanding of what the database told them.
And also, now we're in that 90-day quiet period where states are not supposed to be doing mass purgings of their rolls. I believe it was Alabama, that a court recently told the Secretary of State he couldn't purge the voter rolls at this point.
That's another excellent point there. And so in addition to whether they get the data and what they can use it for, then there's the ultimate question about election law, which is a different question than the immigration law, about whether they can even be doing this at all, even if they get the data, and you're correct, they can't be doing this at all anyway. So that's a larger problem. But just from the immigration standpoint, the government is essentially saying, look, this is going to be a garbage in, garbage out problem, because you're going to get information that's not fully up to date with all the people's exact names about whether they are actually citizens or not and whether they can vote or not.
So now that we've solved that problem, let's move on to the Temporary Protected Status Program. More than 863,000 people currently have been granted temporary protected status as of this fall, and that's more than double the numbers 4 years ago. And about twice as many people are eligible, and tens of thousands are awaiting approval. Start by explaining what the purpose of the Temporary Protected Status Program is.
Well, the original statute, as it was constituted, was the following. Let's say, as an example, we had a bunch of people here from Japan in the country. They were always intending to go home. They came to visit. They came to work temporarily or do something else, study or something. And then, like what happened in Japan where there was that nuclear reactor situation, and suppose the nuclear reactor had gone off and it just wouldn't be safe to go back to Japan until they solved their nuclear reactor situation. The point of TPS, temporary protected status, is, look, get this status so that you don't fall out of status, so that you are considered someone who is complying with the law, and whenever, the nuclear situation is resolved, then you can go back home. So it was always for something like that, or a hurricane, or an earthquake, or a war, or some other natural disaster. But the idea was, that's why it's called temporary. So it's supposed to be for 18 months, and then hopefully after the 18 months, whatever crisis that caused the need for temporary status will go away. But what's happened is that in America, we're a very nice country. We'll have a lot of nice people who don't like to do mean things to people. And so what happens is that once people get TPS, then they have legal status, and people then get very sad about revoking legal status because people start working, they start building roots, they start potentially having children here who are U.S. citizens, and they start building more and more and more equities. And so, for instance, you have a lot of people here who have been on temporary protected status since literally 1996 because of various natural disasters that have happened. They keep being redesignated. So every 18 months they get renewed. And those are people from Central American countries like Honduras and El Salvador. Now, having said that, during the Biden administration, many, many more countries have been added. Ukraine, Venezuela, Yemen, Afghanistan, Cameroon, Haiti. And so the question is, what's going to happen to all of these people if former President Trump is elected to become the president again? Because during the Trump administration, he tried getting rid of TPS for the people that had it, and then there were lawsuits, and those lawsuits couldn't ultimately. But the question is, could Trump, within his term, be able to survive all those lawsuits, revoke everybody, and start getting people out? And would he do it? Would he do it for Venezuelans? Because most of the Venezuelan American citizens are Trump voters, and they may not like it if Venezuela gets yanked from TPS. Or they may like it. Who knows? These are all tough questions to determine, but that would be a very interesting one. Ukraine is another interesting one. What will happen with the fate of the Ukrainians who came here? Will they all be forced to go home? So those are going to be challenging questions for Trump. But yeah, we're at nearly 1 million people with this status. One of the more famous groups is Haiti, where we had that issue with Haiti and Springfield, Ohio. And the point is that the Haitians in Springfield, Ohio all have TPS. And so that's why President Trump is harping on this TPS status to say, look, I want to fight for you and get rid of this and send all of these people home. So that million people, their fates are at stake in this election.
According to the Migration Policy Institute, there are more than 3.3 million migrants with a temporary status that currently doesn't lead to long-term residency. That's under a lot of different programs. And
Correct.
when those programs end, I mean, what happens?
Well, so that's what's going to be the question for the president if Trump comes back into office. If he ends all of those programs, a lot of those people, what they're going to end up doing is applying for asylum, and then they're going to have millions of more cases on top of the millions of cases they already have in the program, plus whoever else the president wants to actually add by, starting to do immigration enforcement actions. You could very shortly have 10 to 12 million cases in the immigration courts. And the question for Trump is he going to want that? And is he going to want to take all of those people out of the gainful economic employment they have now and cause economic instability? Or is he going to start using a more scalpel-like approach and maybe only start focusing on people with criminal issues? I would hope that that's where he would go, because that would be enough where he could placate his base by saying, look, there's too many people to go after. I need to go after the public safety threats. He'd be more than busy for the next 4 years just trying to deport the people with criminal issues. And so I would hope and imagine that that's where he would prioritize, but, we will have to wait and see if he's elected and what they will be doing.
I mean, how many people who get removal orders actually, remove themselves from the country? I mean,
well, very few people do it for themselves. And the larger problem is, can a country actually let you remove people? So that's the problem, is at the moment we can't remove people to Cuba. At the moment we can't remove people to Venezuela. At the moment we can't remove people to Haiti. We can't remove people to Nicaragua. And the question is, does the Trump administration have sufficient levers to reopen up those countries for removal purposes? And that's going to be the real question here. What levers can it pull? Will it actually declare war against these countries? What will it do to actually force these countries to allow our planes to land and to deport people? And that's really going to be the question here.
A lot of questions there, Leon. Thanks so much. That's Leon Fresco of Holland Knight.
Register to vote. Okay? And get everyone you know and everyone you don't know, drag them to register to vote.
And is Elon Musk's $1 million voter giveaway just a disguised way of registering voters in swing states?
Every day from now until the election, we're giving out $1 million prize. That is, and all you have to do is sign a petition in support of the Constitution. It's very straightforward. You don't even have to vote. You don't have to vote. You just have to sign a petition saying you believe in the Constitution.
Musk announced the giveaway in the battleground state of Pennsylvania last Saturday, but didn't mention that to be eligible for the drawing, you must be a registered voter in one of the swing states of Arizona, Michigan, Georgia, Nevada, North Carolina, Pennsylvania, or Wisconsin. Now the Justice Department has sent a letter to Musk's super PAC warning that his $1 million giveaway to registered voters may violate federal law. Joining me is Erin Chlopak, Senior Director of Campaign Finance at Campaign Legal Center. Erin, start by telling us about the law that's at issue here.
Sure. So there's a federal statute, Section 10307C of Title 52 of the U.S. Code, and that statute says that payments for registering to vote and payments for voting itself are illegal. More specifically, it says whoever knowingly or willfully pays or offers to pay or accepts payment for registration to vote or voting shall be fined not more than $10,000 or imprisoned for not more than 5 years or both. So the law makes it explicitly clear that it is illegal to pay people to register to vote.
Now, in this case, Elon Musk says that, what he's doing is getting people to sign this petition that supports the First and Second Amendment. But to sign that petition, you have to be a registered voter. Is that a violation of the federal law?
I think what Musk is doing through this petition pretty clearly does violate federal law. And in fact, it's been reported that the Department of Justice has actually issued a letter to the PAC that Musk has funded to warned them that this activity may well be unlawful, which is a step the Justice Department may take when there's activity that seems to violate the law, to give the person doing it, an opportunity to correct their behavior and basically establish a record that, there may be real legal issues there. And I think what's crucial here, as you noted, June, is that this particular sort of sweepstakes, first of all, is only available to people who have registered or are registering to vote. I believe that the petition itself includes, a link to voter registration sites. Initially, it had an expiration date of October 21st, which was, I think, not coincidentally, the voter registration deadline for Pennsylvania and I think Michigan as well. That date has now been extended, but again, to, a, I think, telling date of Election Day in a number of the states that Musk appears to be seeking to get people to register to vote in do have registration deadlines that, go on through Election Day. So the fact that this sweepstakes is only available to registered voters, that in fact it provides an opportunity for people to get registered so they can participate, I think is a pretty telling indication that the purpose of this is indeed to persuade and pay people to register to vote. And frankly, the petition itself doesn't seem to have any meaningful effect. It's not a ballot measure. It's not some other situation where the petition has some independent function. So the petition really seems to be almost a pretext to the real purpose here, which is to get people to register to vote in swing states.
The argument from the other side of the case, let's say, is that it's not only for people who register now, but also for people who are registered in the past. So does that make the issue a little fuzzier, murkier?
I don't really think so. I mean, I don't think the issue is murky, particularly because the goal appears to be to get people to register to vote. And again, it's being offered as a sweepstakes. So, you may not win it, but the effect of this opportunity, seems quite clearly intended to get people to register to vote, regardless of who some of the recipients are and whether some of them have already been registered.
How unusual is it to have the Justice Department's Public Integrity Section send out a letter like that?
I don't have specific sort of historical data. I do believe that there was at least one example in the past, I think back in 2010, where I think the Justice Department sent a similar letter to Vince McMahon, who owns the World Wrestling Entertainment Organization, who I believe was offering clothing to voters. So, it's certainly not unprecedented. And I think just confirms the fact that, this clearly raises serious legal issues.
How often does the Justice Department bring charges with these kinds of issues?
So the Justice Department has criminal jurisdiction over campaign finance violations. And we certainly have seen a number of times, particularly in recent years, where the Justice Department has stepped in to pursue criminal enforcement of campaign finance violations. And I think, one reason that's happening is because there's a real lack of civil enforcement by the Federal Election Commission, which is the independent federal agency that has exclusive jurisdiction over civil enforcement of campaign finance laws.
Do you think it's likely that he'll be prosecuted?
I think it's too early to speculate about, what may happen in this particular situation. And obviously, given how close we are to the election, nothing is going to happen before then. So, I think it's quite concerning that this is even happening.
Also, on the second day of the sweepstakes, the Super PAC reframed its messaging around the giveaway and described the money as payment for a job so that these people will be spokespeople for America PAC. And subsequently, we saw that there were some testimonials from the two winners online. Does that help Musk's argument?
What I would say is that, I can't kind of get into or speculate about all of the ways in which the investigation might unfold. I think it's really telling that the change happened itself. the sweepstakes wasn't presented that way in the first place. So it seems like, kind of a telling admission that there was this effort to reframe what was happening. And, at the end of the day, the fine print on the PAC's website about the petition didn't seem to change. So it doesn't strike me as a particularly effective way to render this attempt to pay people to register to vote legal.
Any final thoughts?
I do think it's worth just sort of putting this in the larger context of efforts by Elon Musk, is the world's wealthiest person, to use his vast, massive resources to influence the outcome of this election. And, this seems to be perhaps the most egregious example, but it's certainly not the only one. And as, the source of more than $70 million of funding of this super PAC that is spending large amounts of money to influence this election, there are a variety of ways in which Musk is using his outsized resources and ability to amplify his voice in ways that, dramatically, outweigh the voice of ordinary, everyday Americans. And, another example is that the super PAC has spent, I think, as much as $80 million on canvassing efforts on behalf of the Trump campaign, essentially allowing the campaign to outsource a substantial piece of the, work that it does to get people to go out and vote for them. And that's something the PAC is now able to do legally as a result of a decision by the Federal Election Commission to effectively deregulate the law in a way that's completely contrary to what the Supreme Court promised would happen in the Citizens United decision.
Just explain what the Federal Election Commission did there.
So, taking a step back for a minute, in the Citizens United decision 15 years ago, the Supreme Court said that corporations are basically people and have a right to speak through their pockets by spending unlimited amounts of money to influence elections. But an important condition on that decision was that spending would be independent, so not coordinated with the candidates that were being supported. And the court assured us that since that spending would be independent, there would be no concerns about corruption or the appearance of corruption or, any other concerns. And so, when the Federal Election Commission a few months ago issued a decision saying, well, actually, when we talk about coordination, we don't mean efforts to go out and canvass and talk to voters face-to-face and even hand out literature. And in the context of those types of activities, the Federal Election Commission, whose job is to protect voters, not donors, said it's perfectly fine for groups like super PACs and outside entities to coordinate with the candidates that they're supporting on the messages that they're, delivering face-to-face to voters and, again, the literature they're handing out. And so the consequence of that is now super PACs like Elon Musk's PAC and other outside groups can spend unlimited amounts of money that they, as a result of fundraising from people who can donate unlimited amounts of money to them, to carry out the messages that are approved by the candidates that they're supporting and basically allow the candidates to offload all of the expenses associated with those kinds of activities to these outside groups that are not subject to the contribution limits that apply to candidates in their campaigns or to parties. And this is a giant loophole in the rules about coordination. And like I said, completely contrary to what the Supreme Court said would happen in Citizens United.
Thanks, Erin. That's Erin Chlopak, Senior Director of Campaign Finance at the Campaign Legal Center. Coming up next, the prosecutor recommends resentencing the Menendez brothers. This is Bloomberg. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.